Hi, so let's continue on. We're now in a position where we can categorise different terms in a contract as being conditions or warranties or inordinate terms, or at the very least you understand what the differences are. So now it's time for us to really start to think about the factors that are relevant to determining whether or not a representation itself is a term or is not a term. And basically there are a range of different factors that the courts use. So we start by thinking about the language that is used, whether that's in writing or in the conversations that happen. And so in relation to that, we're going to look at J.J. Savage and Sons and Oscar Chess. So Oscar Chess comes up a number of times. And basically in those cases, we're looking at the extent to which the language is used in a statement, the representation, is promissory or otherwise. Next, we're going to look at relative expertise. So the relative expertise of the parties who are involved. Again, Oscar Chess shines in this regard, but we'll contrast that case there with Dick Bentley Productions and Harold Smith. And you'll see also relative expertise is relevant to a degree in J.J. Savage, although to some extent that expertise factor clouds the issues a little bit. Next, courts will look at the importance of the term to the promisee. So the extent to which the term itself induced the making of the contract or was understood by the promisee to be one of the conditions or the promises that was being made to them. Van den Eschet and Chappell, and once again Oscar Chess will help us understand that. The extent to which there is any written agreement, my slides are obviously working in the wrong order here. Let's skip ahead to timing. So the timing of the representation, how close the representation was made in time to the time that the contract itself was made. And we'll use Van den Eschet and Chappell again to understand that. In relation to the form of any written agreement, Equiscorp and Glengallen Investments is in your casebook and is there for that purpose. And we'll be exploring the extent to which a contract might be in draft, or the extent to which matters that had in fact been discussed by the parties were excluded from the final agreement, and what inferences the courts will make in relation to that. And then of course we have that somewhat unhelpful any other relevant circumstances, which suggests that the categories of circumstances where a promissory statement might be made or might be found isn't closed. And so it's open to you in solving these problems to think about the range of these issues. This is an inclusive but not an exhaustive list. And just to recap on the reasons why we care, the categorization of statements as either terms or representation is important for determining the type of action and the kinds of remedies that might be available in the event that the representation itself proves false. If the representation can be categorized as a term, then there are consequences for failure to meet the requirements of that term, to keep that promise as part of the contract. If the term is a condition, then the consequences include the ability to terminate the contract. If it is a mere warranty, then damages might be available. If it is an innominate or an intermediate term, then depending on the severity of the breach, the consequences will follow from that. So breach of a contract term entitles a party to contractual damages and may entitle that party to terminate the contract. In addition, there are laws now, and you need to remind yourself as you read these somewhat old cases, that there is a lot of statutory overlay that is impacting this area of the law now. But there are many laws that give rights in relation to false representations, in particular under the ACL or the Australian Consumer Law, but certainly not limited to that. Financial services laws, laws in relation to door-to-door sales, for example, laws in relation to insurance, laws in relation to telecommunications, all include similar provisions. There's also laws in relation to deceptive conduct generally, and possibly estoppel will arise even if there is no contract. So, how do we work out whether a representation is or is not a term? Ultimately, we start with the language. We look at statements that begin with things like I promise, I guarantee, I warrant. Those kind of things are inherently promissory by nature. However, statements that begin with, well, I would think that, or in my opinion, my best estimate is this, there's a possibility that it might go this fast or happen by this date. Those kind of statements are arguably not promissory in their meaning, and we'll look at that specifically when we get to J.J. Savage in a moment. It's also relevant to look at the relative expertise of the parties. Economists would call this the moral hazard issue, the extent to which one party is more likely to be in a position of authority and to have statements that they make about the subject matter of the contract as coming with that authority or that understanding. So statements that, for example, your doctor makes about the kind of medical service you need are more understood, or more likely to be understood as being weighty in nature than statements that your fortune teller makes about the kind of medical services that you might need. But we'll look at that. Unfortunately, we don't have a case about fortune tellers, but we'll look at that in Oscar Chess in just a moment. So just flicking back, let's start with opinions and estimates. So generally, an opinion is an expression of a personal belief. It doesn't have a promissory nature. But the water gets a little muddied when that opinion is given by somebody who has significant expertise. So where there's a professional opinion. For example, a legal opinion or an independent expert opinion is an opinion of, say, a geologist who is giving you an opinion about the likelihood of a particular area having a mineral resource in it, and that opinion is then published in a prospectus. Is that a promise to prospective shareholders that the ground does in fact contain that mineral ore or not? Or is it just a statement made with best intentions based on expertise and information? These are the kind of issues that come up quite regularly. Before we get to opinions, though, I want to talk about J.J. Savage. The picture on the screen is of J.J. Savage and Sons out in Williamstown. I always think it's nice to do a little bit of trivia, or collect. Maybe one day I'll have a Pinterest page with the destinations for cases that we deal with. So let me tell you about J.J. Savage. So Mr. Blakely wanted to buy a speedboat. In the course of some negotiations relating to the construction of the boat, Mr. Blakely asked Savage's representative, their salesperson, to put in writing their views on some various engines that might be used. So the manager, the salesperson, set out a letter which detailed things like the fuel consumption, power its output, estimated speed, comparative costs, those kind of things. In the letter, he made a recommendation in favour of one type of engine, and he estimated that the speed with that combination of hardware, is hardware the right word, that the boat would go at around 15 miles an hour. Basically, at some point, too, just before signing the contract, Mr. Blakely said something to the effect of that he liked that opinion and much better than what he'd been told by another expert. And so he agreed to buy the boat and clearly wanted it to go 15 miles an hour. As it turned out, it didn't go nearly that fast. And he sued J.J. Savage and Sons for breach of the term of the contract that the boat would go at least 15 miles an hour. So the question before the court was whether the representation in the letter, the estimated speed, was in fact a term of the contract. Ultimately, the court found that an estimate is not the same as a contractual term. Ultimately, this went to the High Court, and the judgment of Sir Garfield Barwick, so Chief Justice Barwick, which was agreed with by Justices Kitto, Menzies, Owen and Walsh, included, and I'm paraphrasing here, so far as being a promissory expression, the words estimated speed 15 miles an hour indicates an expression of opinion as the result of approximate calculation based on probability. And that definition, an expression of opinion as the result of approximate calculation based on probability, came from the dictionary equivalent of the term estimate. And the court found that it wasn't a contractual term. So, an opinion or an estimate, when it's made clearly as an estimate, isn't a contractual term. But what happens when the parties have different levels of expertise? Now, I've mentioned this case a number of times already, Oscar Chess. So what happened here is Mr. Williams sold a second-hand Morris Minor to a company called Oscar Chess, who was a second-hand car dealer. Sold it for £290. It had come into Mr. Williams' possession through his mother. She had purchased it back in 1954, again from a second-hand car dealer, and it had had about 5 or 6 different changes of ownership since 1948. At the time that Mr. Williams sold the car to Oscar Chess, he honestly believed it was a 1948 model. He had told Oscar Chess that it was a 1948 model, and that was borne up by the registration book and the manual that was in the glove box of the car and had been there since it had been bought. Well, it turned out that the car was in fact a 1939 model. It says 38 on the slide, but it was actually a 39 model. And the registration book had been fraudulently altered by a third party well before Mrs. Williams had bought it. So 8 months after the transfer, Oscar Chess sued Williams on the basis that he would have paid, or the company would have paid £115 less for the car if they'd known the true situation. So the claim for breach of contract would only succeed if the court was convinced that it was a term of the contract that the car itself was a 1948 model. And so the issue was whether Mr. Williams' statement that the car was a 1948 model was a warranty to that effect, or was it merely a representation? Ultimately, it was found that it was a mere representation, a statement of belief. The relevant inexperience of Mr. Williams compared to a used car dealer suggests that a reasonable person interpreting the statement wouldn't regard it as a promise to the dealer. So this is using an objective test. The dealer had more experience and was in a better position to know what the car's model is. It's interesting to look at the words that Lord Justice Denning used. Much depends on the precise words that were used. If the seller says, I believe that it's a 1948 Morris, here is the registration book to prove it, there's clearly no warranty. It's a statement of belief. No warranty, a statement of belief. It's not a contractual promise. But if the seller says, I guarantee, sorry, I'm flipping off a bit fast there, guarantee it's a 1948 model, it's borne out by the registration book, but you don't need to solely rely on that. There's clearly a warranty here, I guarantee that it is. The seller is making himself contractually responsible, even though the registration book is wrong. So Denning used this test. What is the proper inference from the known facts? It must have been obvious to both that the seller had himself no personal knowledge of the car, the year when the car was made. So this is the objective test. He only became the owner after a great number of changes had been made. He must be relying on the registration book. It's unlikely such a person would warrant the year of manufacture. The most he would do would be to state his belief and then produce the registration book in verification of it. So we use this intelligent bystander test again. And here Denning says, the seller did not intend to bind himself so as to warrant that it was a 1948 model. If the seller was asked to pledge himself to it, he would have at once said, I cannot do that. I only have the logbook to go by, same as you. So let's have a look now at Dick Bentley. Very similar facts. Bentley told Mr. Smith, a car dealer or expert, that he was looking for a well-vented Bentley car. Smith told Bentley that he could find out the history of cars. So he found a Bentley car, which his dealership, which was Harold Smith Motors, bought, and then wrote to Mr. Bentley, I've just purchased a Parkwood power-operated hood convertible. It's one of the nicest cars we've had for quite a long time. Mr. Bentley came and inspected the car. Smith told him that it had been once fitted with a replacement engine and gearbox. It had done about 20,000 miles since the gearbox had been fitted, and that's what the speedometer showed. Smith offered the car to Mr. Bentley for £1,850 and said that he would guarantee the car for 12 months, including parts and labour. After taking the car for a short spin, Bentley accepted the offer and paid £1,850. As it turned out, the car was a huge disappointment. It was subsequently found that the car had done more than 20,000 miles and that it didn't have a new engine and gearbox. So Bentley sued for a breach of warranty. So the statement that the Bentley car had done 20,000 miles only since it had been fitted with a replacement engine and gearbox was found to be a warranty or included in the contract. So in that case, the court held that Oscar Chess was distinguishable from the facts. Again, Lord Denning was, who was Master of the Rolls at the time, was the principal decision maker. He found that Smith, being a car dealer, had the expertise and was in a position to know, or at least find out about the history of the car. He could have obtained the information from the car manufacturers. There was no reasonable foundation for making the representation as to the mileage, and accordingly, Smith was bound by the representation. It was a term of the contract. So if a representation is made in the course of contractual negotiations for a contract for the very purpose of inducing another party to act on it, and it actually does induce them to enter into the contract, that will be prima facie grounds for inferring that the representation was intended to be a warranty. Of course, this can be rebutted if the representation was made without any fault, so innocent of fault, and it would be reasonable in the circumstances for a representor to be bound by it, for example, as was the case in Oscar Chess. So then we head off, having thought about opinions and estimates and relative expertise. It's time to then think about other factors like timing, importance of the statement, and that kind of thing. So when we're talking about the importance of the statement, what I really mean here is the extent to which the statement itself shows, or the circumstances show, that the statement was highly significant or important to the transaction. The more important the statement is to the transaction or to a promisee's decision to go ahead with the contract, the more likely the statement is to be regarded as a promise rather than some kind of statement of lesser significant. It is worth noting that it's not a one-size-fits-all rule, and it is actually better to be specific and to ensure that all important statements are in fact caught by writing them down in the contract. But winners are grinners, and there will always be some kind of opportunity for discussion on these matters. So let's have a look at Vanden Eschet and Chappell, a 1960 case. It's in the textbook, referred to in the textbook. I don't think that the case itself is in your casebook, but it is worth having a read of. So before signing a contract for the purchase of a house, the purchaser asked the vendor if there were any white ants, termites, in the house. The vendor said no. If there had been any, I would have taken some steps to eradicate them. So the purchaser signed the contract even though the written terms, had no reference to white ants at all. After the purchaser took possession, she discovered termites in the house, and basically they did a huge amount of damage, possibly not as much damage as the slide would show. So the question before the court became whether a prospective purchaser who immediately before signing a contract made a specific request to be informed about a matter and got an affirmative answer, could she argue that it was intended that that affirmative answer was made a term of the contract? Furthermore, on the purchase of the house in this country, an inquiry regarding the presence of white ants was most important because they can do a significant amount of damage. And what would usually happen is that the purchaser would make their own inquiries, but they would do that weeks before. Ultimately here it was found that because the timing of the statement was so close to the time that the contract was signed, that it was more likely to be seen as a promissory statement than one that was made well beforehand. The significance of the timing is relevant both to the size and the nature of the transaction. In Van den Eschet and Chapel, the statement was made immediately prior to signing the contract of sale. There wasn't any time for an independent inquiry to determine whether there were any white ants or termites in the house. If the statement had been made 3 weeks beforehand, the court probably would have found quite differently because there was time for the vendor to make their own inquiries. Then we have this nebulous idea of other relevant circumstances. None of the factors discussed so far is necessarily decisive, and judges often disagree between themselves as to whether a statement is or isn't promissory. Ultimately, an assessment needs to be made on the facts of each case as to whether the statement would reasonably be considered contractual promise by a person placed in the situation in the parties. So the test is always objective. Have a look at the textbook. The court looks to whether a person in the circumstances of the parties would reasonably have considered the statement to be a contractual promise. In the slide pack, you'll see this slide here. What I've tried to do is just have a one-slide checklist to try and distinguish terms from representations. Maybe having this with you in an exam will help you quickly try and distinguish between a representation and a term in the event that you need to do that. So the next case I want to look at is Equiscorp and Glengallen Investments, where we examine the relevance of the form of the agreement. In this case, some investors had entered into a written loan agreement which had been executed, so by executed I mean signed, to borrow some money and to pay some interest. When a court proceeding was brought against them to recover amounts that they hadn't paid, the investors defended the action by trying to rely on an earlier oral loan agreement which provided different terms and would limit their liability. Ultimately, this came before the full court of the High Court, so Chief Justice Gleeson and Justices McHugh, Kirby, Hayne and Callaghan. They found that the respondents, each having executed a loan agreement, were bound by that agreement. That document that was signed after the oral agreement superseded any stage of the negotiation. Having executed a document and not having been induced to do so by fraud, mistake or misrepresentation, the investors or the borrowers cannot now be heard to say that they are not bound by the agreement that was recorded there. For an oral statement to be binding as a term of a party's contract, the statement must have been made as a promise and intended by the parties to be part of the contractual agreement. Intention is, as you know, judged objectively. The court will assess whether or not the statement would reasonably be considered a binding contractual promise by a person placed in the situation of the parties. Assessing the status of an oral statement, courts will consider a number of potentially relevant factors. These include the significance of a written contract, the language used, the relevant expertise of the parties, the importance of the statement, the timing of the statement, and the form of the written contract. The cases illustrate the significance which may or may not be given to those various factors. In the trade, we say that it's not done till it's all done. It is really quite usual in a negotiation for parties to give and then claw back their positions, because everything that somebody gives in a negotiation is usually in exchange for something else. So something might be offered but then never followed through with, because the thing it was offered for in exchange of is also not finalised. So it's very rare for courts to look at draft documents, and they will look at the most recent, and a final executed document will have precedent over any earlier draft or oral agreement. So the importance of signed documents is really important, and we keep coming back to, and I've mentioned the rule in Lestrange and Graucob a number of times. So Mrs. Lestrange owned a cafe, and Graucob Limited was a manufacturer and vendor of vending machines, so cigarette machines basically. And Mrs. Lestrange put an order to Graucob for putting a vending machine to stock cigarettes in the cafe that she owned. She used their standard order form. So she signed a order form which had the title sale. It was a sales agreement, and she returned it to them. The sales representative from Graucob then signed and handed her back a printed order confirmation. The document itself had the terms on it, blah, 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 doesn't matter, but included a really broad exclusion clause. And we're going to keep coming back to exclusion clauses because they make great examples in this situation. So basically the exclusion clause, and this is 1934, so it's before we had trade practices legislation, it's actually a UK case anyway. It basically said that any express or implied condition, statement, warranty, statutory or otherwise, not stated in this document herein in the contract will be excluded. And so, in other words, Graucob weren't making any promises other than the promises that they made in the document. As it turned out, the machine didn't work as expected, and Mrs. Lestrange ultimately sued for breach of contract, claiming a breach of an implied warranty that the machine was reasonably fit for the purpose for which it was sold. Graucob, in response, argued that any implied warranty was excluded by this express term in the agreement here. So the term itself was here in the agreement. Oops, let's see if I can draw it here. So basically what was happening here is that Graucob was arguing, and remember this is before the trade practices laws, that this quite extensive exclusion clause had the effect of, if it was part of the contract, meaning that the implied fitness for purpose warranty wasn't included. And so the issue before the court was whether that exclusion clause could operate, even though Mrs. Lestrange wasn't aware of the term. And ultimately, Lord Justice Scrutton found, if you sign it, you're bound by it, even if you didn't read it. Some words from the judgment: when a document containing a contractual term is signed, then in the absence of fraud or misrepresentation, the party signing it is bound, and it's wholly immaterial whether she or he has read the document or not. And when we think about that, it's a sensible decision. It's consistent in the Australian context with Toll and Alpha Farm, with Chong and Fitness First, or Fitness First and Chong, which is actually just a Supreme Court decision that we've discussed earlier in the semester. Because I think if it were a defence to a breach of contract that you hadn't read the terms, we would end up with chaos. You would be better off not reading the terms and taking your luck than reading the terms and working out what it is that you had to do, because the terms that you didn't like, well, you just wouldn't have to follow them anyway. So we call this the rule in Lestrange and Graucob. So when a document containing contractual terms is signed, in the absence of fraud or misrepresentation, the party signing it is bound regardless of whether the document was or was not read. Sorry, I've got the question there. What were the case facts, the result, and the court's reasons? I think that's something that you really need to make sure that you understand. This has been affirmed in an Australian context in the 2004 case of Toll and Alpha Farm, which is something that we'll look at in a little bit more detail as we continue on. But the words in orange on the slide here provide the Australian context. To sign a document known and intended to affect legal relations is an act which itself ordinarily conveys a representation to a reasonable reader of the document. The representation is that the person who signs either has read and approved the contents of the document or is willing to take the chance of being bound by their contents, whatever they may be. Now, behavioural economists amongst you might wish to question whether or not the court got that piece right, in the sense that, is it really just a blatant bet, or is it just something that people do when they're being predictably irrational? But I can direct you in towards TED Talks if that interests you further. But I think we understand the economic rationale behind this thinking. So the rule also applies to contracts, by the way, that are signed by electronic means, so email, over the internet, on your phone, that kind of thing. And the justification is that by signing a document, the person is indicating an agreement to the terms that are signed or contained in that document. So it's a person's responsibility to ensure that they're satisfied that the terms reflect the agreement that they make. There are some exceptions though. For example, where a document doesn't appear to be contractual, DJ Hill and Walter H. Wright, where a signatory's consent has been vitiated in some way, and we'll talk about Curtis and Chemical Cleaning and Dyeing Co. shortly, also Petlam and Cullen, where there's a mistake as to the nature of the document. But let's continue on now and talk about terms that are incorporated by notice. I often joke that people doing this course will never park their cars, go on a cruise, or go to a dry cleaner again. So let's have a look at one of the dry cleaning cases. Curtis and Chemical Cleaning and Dyeing Co. is a 1951 UK case. Mrs. Curtis took her white satin wedding dress to the dry cleaner for cleaning. She was handed a piece of paper with the heading receipt, and the shop assistant asked her to sign it. Before she signed it, she asked why she had to. She was told that it was because the shop wouldn't accept liability for certain specified risks, including the risk of damage to beads and sequins on the dress. So Mrs. Curtis signed the receipt. But the receipt contained a condition, and you can see it here on the slide. This or these articles is accepted on condition that the company is not liable for any damage howsoever arising or for delay. So an exclusion clause was actually a lot wider in scope than what Mrs. Curtis had been advised. It certainly went well beyond the sequins and the beads. Well, it turned out that it was returned to Mrs. Curtis with a stain on it, and she sued for damages. The shop relied on the exemption from liability contained on the signed receipt. So the question before the court became, can a dry cleaning shop incorporate this exclusion clause on the document? How does this fit with the rule? If you sign, you're bound, including the exemption clause. It fitted in because the signature was obtained by misrepresentation. Failing to draw attention to the width of the exemption clause resulted in creation of a false impression, and as a consequence, the term could not be relied on because it cannot be part of the contract. So, Lord Justice Denning said that if a person signs a written document knowing it to be a contract which governs the relations between them, his signature is evidence of his assent to the whole of the contract, including the exempting clauses, unless the signature was obtained by fraud or misrepresentation. In this case, failing to draw the attention, Mrs. Curtis's attention to the width of the clause, resulted in the assistant creating a false impression. The false impression was made perfectly innocently, but a false impression nonetheless. It's still a misrepresentation, and accordingly, the exemption clause cannot be relied on. In the absence of a signature, the incorporation of written terms into an otherwise oral contract will depend on a range of different things. Whether notice was given before the contract was formed, whether reasonable steps were taken to bring the terms to the notice of the party to be bound. There are lots of different ways that terms can be incorporated by notice. For example, by giving a docket, by displaying terms on a sign, in an advertisement, in a brochure, in a docket, notices on business premises, tickets, receipts, and so on. So let's have a look at one of these where the court had to look at the timing of the giving of the notice with the unusual clause on it. In Oceanic Sunline Special Shipping Company and Faye, Mrs. Faye was injured on a cruise of the Greek islands. She and her husband had booked the cruise in New South Wales through a travel agent. And at the time that they booked and paid for their cruise, they were given a brochure which said they could basically exchange that brochure for a ticket when they arrived in Athens. And it said in the brochure that the terms and conditions would be displayed on the ticket that they collected. So they went to Athens and they collected their ticket. As it turned out, the ticket had a whole heap of clauses on it, and one of them, clause 13, said that any suit against Oceanic must be brought in the courts of Greece and cannot be brought in any other jurisdiction. So the issue in New South Wales here was whether that clause formed part of the contract, because if it did, Mrs. Faye couldn't sue Oceanic for her injuries in New South Wales. She would have to go to Greece to do that, which of course would be considerably more expensive, involve delays, language issues, etc. So the question before the court at this instance was when and where the contract was formed. If the contract was made in Sydney, then that term could not actually be added into the contract. Unless it was formed as part of the contract to start off with. So the High Court found that the contract was made in Sydney, where the passenger paid the fare and the travel agent issued the exchange order. Oceanic was bound to issue the ticket in exchange for the exchange order in Athens and to take the passenger on a cruise on terms that were already agreed. It was too late after the original contract was made in Sydney to add conditions which were not already incorporated. Clause 13 on the ticket couldn't alter the terms of the contract, and that contract had already been made in New South Wales when the cruise was booked. Faye could not reasonably have been expected to become aware of that clause until the ticket was given to the Faye family. So as a consequence, under the laws of New South Wales, the clause itself was contractually ineffective, and as a consequence, Mrs. Faye was not prevented from suing in New South Wales. In other words, notice needs to be given before the contract is formed. Oceanic is authority for this proposition. For delivered or displayed terms to form part of a contract, they must be made available to the party to be bound at the time before the contract is made. If a statement is included after the contract's been formed, it can't be a term, no matter how promissory it is. So, what knowledge of the terms do you have to have? A party with actual knowledge that a document delivered or a sign displayed before or at the time a contract is made contains contractual terms will be bound by the terms. I won't go through Parker and South Eastern Railway Company today, but the slide pack has some additional slides that tell Mr. Parker's story. In the case of a non-contractual document, for example, tickets, vouchers, receipts, dockets, signs, those kinds of things, reasonable notice is required for the incorporation of those terms into the contract. So we'll talk about Thornton and Shoe Lane parking in a moment. With internet contracts, there's an expectation that clicking on an I agree or an I accept or similar button will constitute reasonable notice. It is worth noting, though, that the click wrap, browse wrap cases, so sign in wrap cases, are generally USA cases, and so whilst they will have some persuasive value here, there is potential for the matter to be further debated. So our next dry cleaning case is Causer and Brown, 1952 case. In this case, Mr. Causer took his wife's dress to a dry cleaning shop that Mr. Brown owned. Causer was given a docket on which appeared some printed conditions, including a clause that purported to exempt Brown from any liability for damage to the dress. As it turned out, the dress was returned damaged, and the issue before the court was whether Brown could rely on the exemption clause in the docket. Chief Justice Herring found, Chief Justice Herring found that the docket was one which might reasonably be understood to only be a voucher for the customer to produce when collecting the dress, as opposed to a contractual document containing terms exempting the shop from liability and negligence. The onus was on the shop to prove that the customer was aware, or ought to be treated as being aware, that the docket was not merely a voucher or a receipt, and that it contained some special contractual conditions. Because the shop failed to discharge this onus, the exemption clause was found to be ineffective. So this led to signs in dry cleaning shops, I guess. So the next question that we have in front of us is, when might terms be incorporated by notices or by signs themselves? Some key cases here. I really like Thornton and Shoe Lane. When I first went to London, I found myself wandering around the West End one day and actually looking for the Shoe Lane parking station. It was way before the digital camera and the smartphone, so I can't give you a selfie of me in Shoe Lane, but I'll do that one day. So basically, Shoe Lane car park is in the West End of London. If you've ever been there, very narrow streets, lots of traffic, very, very busy. If you haven't driven around that area before, it's really, really quite difficult. So basically, Mr. Thornton was a musician. He might have actually even been a trumpeter. He was booked to play with the BBC Orchestra at Farringdon Hall, not far away. So he drove into the city and he went to park his car in Shoe Lane Parking's multi-level automatic car park. He'd never been there before. He drove into the car park, stopped at the automated ticket dispensing machine. The ticket came out of the machine. He took it and he parked his car. The ticket had some words on it that said that it was subject to the conditions that were displayed on the premises. As it turned out, he couldn't see those conditions from where the ticket machine was. He didn't see them before he drove in, and they weren't immediately visible at any of the places that he was. But the signs basically said what the cost of parking the vehicle was, and at the bottom of the sign it said something like all cars parked at the owner's risk. So the condition purported to exempt Shoe Lane parking from liability arising from damage to the car, as well as for injury to the customer, howsoever caused. So he went on into the car park. His car was taken up to another floor by mechanical means. He went, played his trumpet in Farringdon Hall for 3 hours. He came back, went to the office with his ticket, paid for the duration of his stay. His car was retrieved by mechanical means. As he went to put his belongings in the boot, there was an accident and he was severely injured. So he sued for damages in tort. And the question before the court was whether or not the liability exemption condition formed part of the contract between the car park and Mr. Thornton. So the question was, not so much was it broad enough to exclude Thornton from his damages claim in tort, but whether or not the term could be incorporated by notice. Court found that it was relevant that he'd never been to the car park before. He hadn't seen the signs. They weren't visible from the entrance or from the place where the ticket was issued. He'd seen the small print, but he hadn't read it. And the condition purported to exempt them, so it had a very broad exemption provision. Ultimately, it was held that the customer will be bound by the exempting condition if they know the ticket is subject to it, or that the provider of that clause did what was reasonably sufficient to give the customer notice of the clause. Here, the conditions that were displayed in the car park weren't visible, either from the entrance or from the place where the ticket was issued. So they found that Thornton or the customers were not bound by the exclusion clauses. There was no reasonable notice. Customers didn't know that the tickets issued were subject to the exemption clause. One of the things that followed from this case is since then you will notice as you drive into a parking station, the conditions will be displayed on a sign. They're almost impossible to read if you've got old lady eyes like me, but you can see them as you drive in. I'm not sure that any reasonable person could read them all with 15 other cars honking their horns behind you, but you'll find that at most parking stations there's somewhere between a 5 and 15 minute free period at the beginning, and really that comes from this case, that there is this idea that you've got a period of time to absorb the terms. You can go in, and if you don't like them, you can turn around and come out without having to pay any money. So the last case that I want to talk about today is Balmain Ferry. So I want to talk about this in the context of a previous course of dealings. Contractual terms of earlier transactions may be incorporated into a subsequent contract based on the history of dealings between the parties. Balmain Ferry and Robinson is a case that may well be known to you in the context that you've seen it in torts. Here I just want to talk about the contract issue. So Mr. Robinson, who is a lawyer, travelled on a ferry numerous times previously, so he was deemed to be aware of the terms of business. So let's have a look at the case itself. Balmain Ferry had a sign over the entrance to their wharf stating that a fare of 1 penny must be paid by all persons entering or leaving the wharf, no exception, whether the passenger has travelled or not. Mr. Robinson was aware of the conditions. He regularly travelled on the ferry. On the occasion in question, he paid the fare of 1 pence and was admitted to the wharf through a turnstile, but he missed his ferry. He wanted to leave the wharf by another turnstile and was asked to pay a penny, but he refused to pay that second penny. And Balmain argued that Robinson was contractually bound to pay the penny and obliged not to leave the wharf until he had done so. Justice O'Connor held that Mr. Robinson was bound by a term of the contract requiring the payment of a penny to leave the wharf. Having travelled on many occasions on the ferries and paid his fare, Robinson had entered the wharf with knowledge of the terms upon which the ferry company conducted their business. You might want to contrast that with a more recent decision of Rinaldi and Precision Mouldings. In that case, the appellants provided transportation services for the respondents' goods. Parties had had some previous dealings, performing the same services under the same contracts 9 or 10 times in the past. In every previous dealing, a cart note, as it was called, containing the price, also contained some terms and conditions on its reverse side, and one of those terms and conditions protected the appellants from a claim for damage done to the goods by the negligence of the appellants or their associates. In this particular case, the court noted that for documents to be considered a course of dealing, they need to be reasonably considered contractual in nature. The cart notes in that case were never considered to be part of the contractual terms. Therefore, the previous use of them couldn't amount to a previous dealing in a way which allowed for the incorporation of further terms.